Okay, so have you ever been in like a real estate situation that just went totally sideways?
Oh, I bet. We're talking co-owning property in California, and suddenly it's all gone sour.
Yeah, like inheriting a house, but your siblings are making it impossible, or that business deal that's totally blown up in your face.
And you keep hearing this term, partition action, but what does it even mean?
Yeah, exactly. And that's why we're doing this deep dive today to like really break it down.
We're going to unpack all the legal jargon around partition actions in California, how they work, and whether it could be, your way out of this real estate mess.
But make sure you have those aha moments. And by the end of this, you'll be ready to handle even the trickiest property situations.
So you're empowered to make those informed decisions. Okay, so let's start with the absolute basics. What exactly is a partition action?
Right. It sounds kind of serious, like, are we splitting a country in two here or something?
Well, maybe not that dramatic, but it does involve dividing something pretty important, right? Your property.
Okay, I'm listening.
So imagine you and a friend, you're super excited, you decide to open a lemonade stand together, right? But then you can't agree on anything.
Oh, no. The recipe, the schedule, who takes the money, it all goes downhill.
Exactly. A partition action is basically going to a judge and saying, help. We need to divide this lemonade stand fairly, maybe even sell it so we can both move on.
I love that analogy. Like hitting the reset button on a messy partnership.
Exactly. And our research shows just how common these situations are. It's siblings fighting over houses, exes who can't agree, even business partners at a standstill.
It's interesting because you'd think it's just about the property itself, but it feels like there's always this whole human story going on underneath.
Right, absolutely. You're talking about deep emotions, family history, financial stress. It can get messy.
Definitely. And that's exactly why understanding your legal options is so important, right? So you can be strategic and protect what matters most.
Right on. Knowledge is power, especially when it comes to real estate. So let's get down to it. How does a partition action actually work here in California? Is it as scary as it sounds?
Honestly, the name is way more intimidating than the process itself. Think of it like a structured path to sort out those co-ownership disagreements.
So no surprise appearances by Judge Judy.
Haha, not quite. Way less drama than TV court, I promise. Here's how it usually goes. One co-owner, the one who's feeling stuck, wants out, so they file a complaint with the court. That's what officially gets things moving.
Okay, so it all starts with that initial filing. Makes sense. What happens next?
Then the court steps in, and they appoint this neutral third party called, you guessed it, a partition referee.
A referee like in a game?
Yeah. Think of them like a referee in a basketball game, making sure everyone's playing by the rules and things stay fair.
So they're like the impartial mediator throughout this whole thing. Got it.
Exactly. Now, in most cases, this referee will recommend that you sell the property on the open market. That way, you're most likely to get a fair market value for your share. Right, got to make sure it's a fair deal.
Right. However, there are times when one of the co-owners might decide to buy out the other owner, so they end up keeping the property entirely.
Interesting. So there's some flexibility there depending on what everyone wants.
Right. And once the property's sold, whether it's to one of the co-owners or a third party, the money from the sale is divided up among the owners.
So if I own, say, 50% of the property.
Then you'd get 50% of what it sells for. Makes sense, right?
Totally. Keep things fair and square.
That's the goal.
Now, our research uncovered something kind of interesting about that initial filing, that complaint. Seems like along with it, you also file something called a lis pendens. What in the world is that?
Yes, the lis pendens. Think of it like a public announcement. It lets everyone know there's legal action happening with a particular property.
Gotcha. So like a big caution sign for anyone else who might be interested in that property.
Exactly. It's a safeguard, right? Because it makes it much harder for the other owner to try and, let's say, pull a fast one and sell the property out from under you while everything is still in process.
So it adds a layer of protection while the case does its thing. That makes a lot of sense. But it also sounds like from our research that co-owners can actually try to work things out before ending up in court, right?
Absolutely. In fact, it's usually the best first step if possible.
Tell me more about that. It seems less, scary than going through a whole trial.
Totally. We're talking about mediation. It can be a real game changer for these kinds of situations.
So what exactly is mediation?
So mediation involves a neutral third party, a mediator, who basically helps you and your co-owner talk to each other, productively. And unlike a judge, the mediator isn't there to make any decisions. They just help you both communicate, find some sort of common ground, and hopefully come to an agreement you're both okay with.
So it's more like guidance than a ruling.
Exactly. It's a much more collaborative approach, right? Less about fighting, which, let's face it, is especially helpful when you're dealing with a situation that's already emotionally charged.
And I imagine it's a lot easier on the bank account than a full-blown legal battle too, right?
You got it. Mediation can save everyone involved a ton of time, money, and stress. It's definitely worth considering.
Okay, mediation sounds like a solid first step then. But let's say you've tried that, it hasn't worked out, and now you're really thinking about a partition action. What are the main benefits of going this route, specifically here in California?
Well, I think the biggest advantage is it gives you a clear legal path to actually resolving what might feel like an impossible situation. It's kind of like having a legal tool you can use when just talking about it isn't enough.
Like a last resort option when things get really bad.
Exactly. And here in California, the law actually recognizes what's called an absolute right to partition.
Okay, what does that mean?
So basically, it means that if you own property with someone and you want out, in most cases, the court's probably going to allow that property to be sold even if the other owner's dead set against it.
Wow, that's huge, especially for someone who feels like they're just stuck.
It's all about giving that individual owner some power back, right?
Absolutely.
And this right to partition, it covers a really wide range of situations. Houses, empty land, even commercial buildings. And it doesn't matter if you're joint tenants, tenants in common, even business partners.
So it's a pretty versatile tool.
Absolutely. It's designed to be fair. Remember, when that property is sold, the money from the sale is divided up among the owners based on how much they each own.
Right, so everyone gets their fair share, even if they couldn't agree on how to handle the property together in the first place. Okay, that makes sense. Now, let's be real for a second. How much is this going to cost?
I was waiting for that one. It's definitely something everyone thinks about, and rightfully so. The exact costs can be all over the place depending on how complicated the case gets. But generally speaking, a partition action in California could cost you somewhere between $8,000 to $12,000, give or take.
Okay, so not chump change. That really highlights why trying to figure things out amicably, like with mediation, could be a smart move if possible.
Oh, absolutely. Those costs are a pretty strong motivator to find another solution. However, it's important to remember those costs are typically shared by the co-owners. It's not like one person is stuck with the entire bill.
Right, splitting it makes it a little less scary. Our research also mentioned something interesting about potentially getting those costs back. Something about attorney's fees.
Oh, yeah, this is a big one. So in California, the law actually lets you potentially recover attorney's fees during partition actions. Basically, if you're successful in your case, the court can order the other owner to pay some of your legal fees.
Wow. That could really offset a big chunk of the costs. Suddenly, it's not quite as daunting.
Right. And that's why having a good lawyer in your corner is so important, especially one who knows the ins and outs of partition actions. They'll not only help guide you through the whole process, but also fight to make sure you're protected financially, including, like we said, potentially getting those legal fees covered.
It's like having someone who knows all the rules and can help you play the game strategically. Okay, so we talked a lot about the potential upsides, but what about the downsides? Is there anything people should watch out for if they're considering a partition action?
Well, even though partition actions are usually, let's say, less intense than some other lawsuits out there, they do still involve going to court. And anytime you're dealing with the legal system, things can be a little unpredictable.
So you're basically letting the court make decisions about your property.
In a nutshell, yes. And that means you have to be prepared to accept whatever outcome the court decides on.
That's a good point. It can be a little unnerving to relinquish that control.
And even though things usually move a bit quicker than some other legal cases, it still takes time. There are court dates, paperwork, sometimes delays. It's not unusual for a partition action to take several months, sometimes even a year or more, to fully resolve.
So patience is definitely key.
Absolutely. And speaking of things that can take time, another potential downside is the whole selling price thing.
Right, because you're essentially forcing a sale of the property.
Yeah.
And there's no guarantee it'll sell for what you want, is there?
Exactly. In a perfect world, the property would get snapped up for top dollar and everyone would be happy. But the reality is, whenever you have a forced sale, there's always the risk it could sell for less than you hoped for.
Especially if the market's down.
Exactly. So it's important to go into this with your eyes wide open.
Be realistic about what that sale price could be.
Got it. Now, before we move on, I did want to circle back to something you mentioned earlier about community property being treated a bit differently when it comes to partition actions. Oh, right. Good catch. Community property. That's property that a married couple acquires during their marriage, right? Well, in California, that falls under a whole other set of rules. Unlike other types of co-ownership, community property is considered equally owned by both spouses. It doesn't matter whose name is actually on the title or who bought it.
So it's like a 50-50 partnership by default.
You got it. And because of that equal ownership, you can't usually file for a partition action for community property while the couple's still married. If they want to divide things up, that's typically handled as part of a divorce or legal separation.
So it's considered a family law issue in that case, not purely a real estate one.
Exactly. But here's the thing. If that community property was already divided as part of, say, a divorce settlement, meaning each person now owns a share,
then it could be subject to a partition action down the road.
Exactly. It gets complicated, but in those situations, the court would basically treat the divorced couple like any other co-owners.
It's a really important distinction, especially for anyone dealing with property that was part of a marriage.
Okay, so much good info here. One last thing before we move on, I have to emphasize how important it is to have expert legal advice on your side. You've touched on this throughout our conversation, but why is it so crucial, especially when it comes to these partition actions?
Think of it this way. Navigating a partition action, especially in California, is like trying to find your way through a maze. But this maze is full of legal procedures, paperwork, and, let's just say it, potential traps.
Right, it's easy to get lost without a guide.
Exactly. A good attorney is like that guide. They can help you see challenges coming, put together a solid legal strategy, and fight for you every step of the way. Plus, they know California's partition laws inside and out, which can be, let's be honest, pretty complicated.
It's like having a secret weapon, someone who can help you navigate this complex legal game. Right. And remember, even if you and your co-owner are getting along, having your own independent legal advice is crucial. That way, you're 100% sure you understand your rights and what you can do before making any big decisions. It's your future, after all.
Absolutely, like having a second set of eyes to make sure you're not missing anything important. Okay, so we've been focusing a lot on physical property, houses, land, that sort of thing. But what about things that are less, tangible? Could you use a partition action to split ownership of, say, intellectual property?
Ooh, that's a good one. It really makes you think about how property law applies to all these different parts of our lives.
Right, like a song or an invention.
Exactly. Partition actions are usually about real estate, but the basic idea is dividing something that's jointly owned, right?
So theoretically, if you can own it together, there should be a way to legally divide it.
If only it were that simple. Here's the thing. Intellectual property, it's not a house. You can't just, split it down the middle.
Right, it's not like you can physically divide a patent or a copyright.
Right, exactly. It's more like a legal right than a physical object, which makes things a bit messy. And the truth is, in California, there's not really any clear legal precedent for using partition actions to divide intellectual property.
So it's kind of a legal gray area right now.
For now, yeah. But who knows what the future holds? The law is always changing. As intellectual property becomes more and more valuable, we might see new legal strategies pop up to deal with co-ownership issues in this area.
That's something to keep an eye on for sure, especially for entrepreneurs who are collaborating and creating new things.
Absolutely. And it just goes to show why having an attorney who knows the ins and outs of both real estate law and intellectual property law is a game changer. They can help you navigate these complex situations and figure out the best way forward.
Well, there you have it. We covered a ton of ground in this deep dive. We talked about what a partition action is, how it works, all the little details about community property, getting those attorney's fees covered, and even whether you can apply these principles to things like patents and copyrights. Hopefully you're walking away feeling way more confident about all of it.
And remember, even though these co-ownership disputes can be stressful, they don't have to turn into complete nightmares. By arming yourself with information, getting expert advice, and considering things like mediation, you can approach these situations strategically.
Couldn't have said it better myself. Well, that wraps up our deep dive into partition actions in California. We hope you learned a lot, and more importantly, that you feel empowered to tackle any real estate challenges that come your way. Thanks for joining us on this deep dive.
Call now 714-442-9741. Thank you.